Welcome, everyone, to the final session in this conference. We're going to go out with a real bang. We've got a fantastic panel on democracy, civic engagement, and constitutional reform. Ever since I was a barrister in short pants, I've idolized our next speaker. Mary Eberts is one of the finest litigators our country has produced, and we won't have time to go into her background, but a legend at the bar and in the bar as well, in fact, in many bars. And she's going to address us on a very provocative talk. Is it possible to defang the override? Welcome, Mary.
Thank you very much. I'd like to begin today by offering some comments on constitutional dialogue from an outsider's point of view. Oh, yeah. The conventional dialogue discussion is about courts and legislatures, and it is usually undertaken by either academics or participants who have a favorite contender in that race or in that competition. I have been involved in advocacy on behalf of minorities and then under the Charter and before, and I have to bring that perspective to you today. And then after that, I would like to look at Section 33 in the context of the whole Charter as I have come to understand it, seeking a way to knit Section 33 into the vision of a system where both courts and legislatures are expected to consider the Charter, but given guidance and leeway from the Charter on how it is to be implemented. Senator Forsey remarked that the Notwithstanding clause is there, and if this dagger, he says, is flung, the courts will be as powerless to protect our rights as they were before there was a Charter of Rights. Well, what was it like before 1982? There was a conversation between legislators and at least the segment of the public with which I identified as we sought changes in legislation to promote the rights of women. Representations before legislative committees, demonstrations, public meetings, and one-on-one contact with legislatures furthered in these discussions. The National Action Committee on the Status of Women introduced a yearly systematic lobby of parliamentarians. A Royal Commission on the Status of Women reported in 1970, and their proposed reform agenda was taken up by Status of Women committees outside government and also tangentially attached to it. The venues for these conversations also included the courts. The campaign of Dr. Henry Morgentaler and his supporters for women's free choice brought him into courtrooms long before the celebrated Supreme Court decision about abortion rights under the Charter. A court case, even an adverse decision, could be a powerful impetus for change. Academics had been working for years on careful studies of the balancing claim in family property, as had law reform commissions, but reform of family law was proceeding very slowly. The Supreme Court case of Murdoch and Murdoch galvanized public opinion and brought the issue of family property reform up near the top of the legislative agenda. Irene Murdoch, an Alberta ranch wife, lost her claim to a share in the family ranch, although she had done, and I quote, haying, raking, swathing, mowing, driving trucks and tractors and teams, quietening horses, taking cattle back and forth to the reserve, dehorning, vaccinating, branding, anything else that was to be done. She had sole responsibility for the ranch for 5 months a year. The courts, hearing her claim, agreed with her husband that she had done just about what the ordinary rancher's wife does. Contending all the time with legislative indifference or prioritization of issues that were not seen as merely the preserve of special interests, the idea of an entrenched Charter of Rights appeared very attractive to us when it was put on the table in 1980. Charter rights would be a countervail to political preferences and majoritarian beliefs. And I'll leave the story of women's role in improving Section 15 and securing 28 to another day. I must say, however, that there were some reservations about giving the courts a role in adjudicating rights issues. The track record under the Canadian Bill of Rights was shabby. In the Bedard and Lavelle case, for example, the Supreme Court held that the bill's guarantee of equality before the law was ineffective against Section 12(1)B of the Indian Act, taking away a woman's Indian status if she married a non-Indian. The majority of the Supreme Court held that the section provided no substantive right to equality, merely the right to have an equal treatment in the administration of the law in the ordinary courts of the land. Justice Ritchie was outraged by the idea that the Bill of Rights might render inoperative all legal provisions whereby Indians as such are not dealt with in the way the general public is. He stated that if that had been Parliament's intention, it should have used the override provision in the Bill of Rights. So even at that time, override was a subject of discussion. And more importantly, when it passed the Canadian Human Rights Act in 1977, Canada specifically provided that it would not apply to the Indian Act. That position lasted until 2008. Bliss v. Attorney General of Canada involved a claim for unemployment benefits by a woman who wanted to work despite her pregnancy and could not find a job. She was not eligible for the Unemployment Insurance Act special benefits and claimed general benefits under Section 46. When denied, she challenged under the Bill of Rights this unequal treatment. Justice Ritchie adopted the reasoning of Justice Pratt in the Federal Court of Appeal. If Section 46 treats unemployed pregnant women differently from other unemployed persons, be they male or female, it is, it seems to me, because they are pregnant and not because they are women. The fate of Stella Bliss, Ms. Bedard, Ms. Lavelle, resulted in strenuous efforts to make clear that substantive equality is protected by Section 15, and we were largely successful doing that. However, when the matter came before the Supreme Court of Canada in Andrews versus the Law Society of BC, and we put forward the argument that substantive equality was protected, we did have some doubts about whether the court would accept that position. I worried for some months about whether we were going to be successful, because if we were not, in a charter, an entrenched charter situation, then we really faced doom. Had the court ruled against us, women and other equality seekers would have been farther behind than we had been before. And this is the position that advocates of free collective bargaining were in when the court decided that the freedom of association guarantee did not protect free collective bargaining, and it's taken a long time to work back from that. What's the lesson from all of this? Well, one of the lessons from before 82 was that a pragmatic approach to rights is necessary. The reality of the pre-charter years teaches that institutions are fickle. Sometimes the legislature will be a better protector of rights than the court, and sometimes the opposite is true. And neither institution will be an assured source of protection for all charter values all the time, even when its record in some areas is quite admirable. The other lesson is to distinguish between legislatures and the people. Women and members of other minorities are still not represented well in legislatures. The majoritarian interests of legislators cannot be depended upon to protect minority interests. To increase the likelihood of that happening, minorities have to rally extra legislative support for minority rights. Sometimes that support will be found in the courts, sometimes it will not. But a court decision in favor of minority rights will not end the process, but often will present a new beginning for the parliamentary consideration of the issue, starting from a different set of premises. After a court decision adverse to minority interests, the struggle continues and often devolves into a contest between legislatures as representatives of one form of majoritarian view and the ad hoc, issue-by-issue assemblage of supportive persons outside the legislature. Which group will prevail? Powell and Morton suggest that court decisions can present a specious finality, and disputes will only be resolved by a broader political process where organizational strength, not legal principle, prevails. That broader process may well be lengthy and involve many resorts to court before it concludes successfully. I leave for now whether my attachment to people outside of legislatures would take me as far as suggesting that a referendum has a place in constitutional deliberation, and turn now to section 33. And the reason why I believe that the turning our attention again to section 33 is important is largely because of the experience with the Ford government in Ontario. I remember during the Harris years here doing a number of cases opposed to the Harris government's idea of appropriate merger of various hospitals. And I remember saying to a reporter from the Christian Science Monitor who had come from the States to witness our curious constitutional doings up here in Canada, that under our system of democracy, the element of self-restraint is required of legislatures because there aren't hard and fast rules about what is forbidden. And I have thought so often about that observation during the Ford years, when government has exhibited no self-restraint and no restraint that is based upon a considered view of what the Charter provides. So now I turn to a consideration of Section 33 in the context of the Charter as a whole. The majority of the Supreme Court in the City of Toronto case emphasizes the primordial importance of the constitutional text. And Justices Brown and Chief Justice Wagner describe the court's approach as purposive constitutional interpretation, which begins with and is grounded in the text. So I turn to the text. Section 33 does not mention the courts or judicial review. It addresses only legislative behavior. Apart from procedural requirements of a declaration and reenactment of a declaration at the expiry of 5 years, there are no other apparent limits on the legislature's discretion with respect to imposition of Section 33 on Sections 2 and 7 to 15 of the Charter. Section 24(1) identifies a role for the courts, and that is that anyone whose rights and freedoms as guaranteed by the Charter have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. With respect to this text, one might ask, what does it mean to have freedoms? Are the freedoms guaranteed by the Charter if they are subject to Section 33? Were they denied if Section 33 was imposed upon them? And if the answer to that question goes the right way, then I suggest that it is possible to take a matter to court under Section 24 where Section 33 has been used to override rights. And you don't have to restrict yourself only to the other rights in the Charter that are not amenable to override. You can use the whole thing because you argue that a particular right has been is guaranteed in the Charter, there it is, and it has been denied through use of Section 33. And that would take you to a full hearing of the denied rights and the legitimacy of the legislation doing so. Section 52 is the supremacy clause, providing that any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. So what does it mean for it to be inconsistent with the provisions of the Constitution? The provisions of the Constitution stand in 2 and 7 through 15, even if they are subject to the override. They are still provisions of the Constitution. And so that is another fruitful statutory or textual place to look for a basis for challenging the override. I'd like to look at the other provisions of the Charter to continue this discussion. The preamble provides that Canada is founded upon principles that recognize the supremacy of God and the rule of law. I believe that this preamble may give us, in spite of the reasons of the Supreme Court, the option of invoking the principle of rule of law. Similarly, Section 1 of the Charter specifically refers to a free and democratic society as the context in which to determine whether government measures that have been found to affect a charter guarantee may be justified. And there again, the mention of free and democratic society may permit us specifically to bring in the unwritten principle of democracy. Section 1 places limits on both legislatures and courts. It provides a standard with which the courts must apply in considering legislative behavior. Courts are not left to make standards on their own on an ad hoc basis. They have to stay within the guardrails of Section 1. And again, and similarly, Section 1 is to influence government decisions about legislation and government interpretation and application of Section 1. So how does that all fit in with what I'm talking about here? For example, let me look at Section 32(2). It delays the coming into force of Section 15 for 3 years. The purpose of this hiatus was to give governments the opportunity to review their laws and make their own determinations about whether they contained charter violations. This preference for government and legislative action makes clear that the framers of the Charter trusted legislative judgment on this important issue. Not only that, it probably reflected a view that legislatures are better placed than courts to take on the relatively new and challenging work of ensuring equality. It also confers on the legislature a special responsibility with respect to the rights in Section 15. The careful review of legislation in light of the Charter is part of that responsibility. And for the Charter to impose that obligation on legislatures with respect to Section 15 suggests that we may also argue that they have the same responsibility with respect to other sections in the ordinary application of the Charter. Other things that are important, I believe, are the mention in the non-affected provisions of the multicultural heritage of Canadians. Once again, as have done some of the applicants in the Hake case, they argue that this specific reference opens the door to the application of the principle of protection of minorities. And again, these specific references drawing in these principles are important to overcome the Supreme Court's rather standoffish attitude towards their use. It is also the case that the provisions of Section 28 are free of the override. Let me just turn to those for a moment, and that is Section 28 is contended in Hake to be a guarantee of substantive equality for women, and the language of the section says that it operates notwithstanding any other provision of the Charter, including the notwithstanding clause in Section 33. The Supreme Court has held that Section 15 of the Charter provides rights to substantive equality. One possibility of legislative interpretation is that Section 28 provides substantive equality merely because of some form of incorporation by reference of the substantive equality guarantee in Section 15. If that is so, then does the notwithstanding part of Section 28 continue the important relationship with Section 15, even though 33 means that the legislation operates as it would if Section 15 were not present? I prefer the argument that Section 28 provides for the substantive equality of women and men entirely on its own, without the need for reference to or incorporation of any other charter section. And the legislative history of Section 28, I contend, bears that out. Even more telling than the legislative history, however, is an argument based largely on the text of 28 in the context of the Charter as a whole. The women referred to in Section 28 are in their own right the holders of the full panoply of rights guaranteed in the Charter. They are as complete in their rights holding as men, who have long been the apex rights holders in our legal and constitutional system. By reason of Section 28, women too are apex rights holders in a system of both substantive and procedural guarantees. The weight and significance of this designation cannot be lessened simply because invocation of Section 23 has taken certain rights out of play with respect to one statute for 5 years. And the concept of intersectionality, now well established in rights jurisprudence, would, I contend, apply to the application and interpretation of Section 28. Women are not a homogeneous group. Minority women, by reason of their minority, disabled women, and other identifiable kinds of women are protected under the Charter in their whole, and that is that women, minority women, who have particular rights to a particular interest in religious expression would, I say, be protected. Well, how do you get all this before the courts? I believe that an application should allege that the rights purportedly overridden by Section 33 have in fact been violated. And they should also, of course, call on or invoke any other rights that are not overridden by Section 3 that might be offended. And then the analysis will include all of those rights, and it would not necessarily have to result only in a declaration. The court can overrule the legislation that is purportedly protected by Section 33. This is important because it means that a legislature cannot simply go back and invoke Section 33 again to overcome the force of the declaration. But if the court declares that the legislation is inoperative because of Section 52, if it rules against it in a total fashion, then I believe that we are in the position where, at the very least, a government determined to continue is going to have to not only review the Charter, but review and discuss with interest groups how their interests are affected. And I take this from a case, Nape, from Newfoundland, where the Supreme Court of Canada said that the government could overrule an agreement for implementation of pay equity for healthcare workers. The government admitted that doing so was discrimination, but they said that they needed to do it because of an economic crisis. Significant for the court were the facts that the legislature had looked at other options before choosing to override the agreement, and also that it had consulted with the affected people. So these standards for the exercise of economic power, where the courts are very deferential to the legislature, I believe can be a useful guide for us in any attempt to bring Section 33 activities under judicial review. Let me end on a lighter note. The Hack case has incidentally revealed what may be the most effective strategy of all to overcome Section 33. The Superior Court judge, Justice Blanchard, noted in his judgment that the Premier had once said that he used the override to avoid long court proceedings. He commented wryly that perhaps it was not working out quite that way.
And now you know why Mary is such a formidable barrister before the courts. There's an argument there, and it hasn't yet really been made or entertained by the courts. And I look forward to that one day being the case. I guess the question, and we'll get to it in discussion, will be how, in the case of a law that clearly does involve an infringement so egregious as the type that you are describing, where Section 33 would be called into question, what happens to Section 33? What kind of declaration is made? Or otherwise put, if you can have Section 33 and still have the argument for rights infringement before the court as a justiciable question, and one of consequence, how does that law operate notwithstanding the provision of the Charter? How does it operate notwithstanding the provision of the Charter? How do you have both things at the same time?
Just to anticipate the discussion,
Yeah.
I think that the point of it all is to challenge, through just a straightforward challenge to, the law, because it violates all these sections. The point is challenging the validity or the legitimacy of the application of Section 33.
Sure.
And if you can get a ruling that Section 33 was not correctly used, it takes away its protective
Oh, of course, no,
effect.
of course it
So
does.
that's how
Yeah.
you deal with that. You're aiming at 33, but you're attacking the legislation.
Sure.
And if you get a ruling that the court or the legislature improperly or missed out something in applying Section 33,
Right.
then I believe you can go on from there, and
Right.
and it's not, the legislation isn't protected.
Well, it wouldn't be, of
33.
course, in that case. Yeah, sure.
That's what-
There's a kind of bootstrapping going on there, but we'll come back to it. I want to invite Tsvi Kahana to come up. He's here all the way from Israel, so I don't know if you're tired, but I'm delighted and thrilled that you're here, and he's going to talk about many things, including the definition of tyranny.
Thank you, Peter, for inviting me. So initially I thought I'm going to talk about dialogue, and then Peter and I decided that it's better to present a paper that is forthcoming fully soon. Law journals in Canada are very slow, as you know. And what I tried to do, and so I'm going to present a version into the book. I'll contribute a shorter version of the law review article. And here I will introduce the idea. It starts with a quote from John White, who was there, one of the brokers of the Notwithstanding clause deal, and one of my mentors. And he said this in 1990. The anxiety that produced the political demand for entrenched rights cannot rationally be calmed in the face of the legislative power granted by Section 33. That anxiety is simply this: political authority will, at some point, be exercised to impose very serious burdens on groups of people when there is no rational justifications for doing so. So I wanted to see if John White was right. And what I did, I looked at all the uses of the Notwithstanding clause to date. In fact, when the article was submitted, the title wasn't so neat. It was 1982 to 2019. But now, assuming that in the next 5 days there won't be a use of the Notwithstanding clause, it's going to be the first 40 years. So maybe the pace of the law journal is such a bad thing. And of course, John talks about very serious burdens. I'm going to ask, what is a very serious burden? So I don't know for sure, But I know that we are all scared of the tyranny of the majority. In fact, the intuitive reason to have a Bill of Rights is tyranny of the majority. In fact, as sophisticated as we are as academics and talk about dialogue and interaction and so on, over dinner, you wouldn't be able to explain to someone, I think, the justification for a constitution based on any other reason than the need to protect the minority. So I worked with that term. I'll say right away, I didn't figure out the magic of what is tyranny exactly. But I have a working definition, and I have contextual factors to determine if a certain use of the notwithstanding clause is tyrannical. And the way I look at it, I think that we can say that tyranny occurred when a given use of the notwithstanding clause is either motivated by a desire to disadvantage minorities or silence opposition, motivated, that is, if we have a non-benign motivation, or when the result is exceptionally severe rights violations. Again, the two obvious questions. First one is, how do you determine motivation? What, do you read thoughts? So the answer is yes. As an academic, I'm allowed to make a value judgment about something that took place. And as I will tell you soon, I think, for example, Bill 21, whatever justification it could receive in retrospect, I think it was motivated by Islamophobia. And I think that makes it tyrannical. Now, it's a judgment, but I stand behind the judgment. So either tyrannical motivation or exceptionally severe right violations. Now, in the paper, I go through a great length. I look at three bodies of knowledge: rights theory, constitutional theory, and constitutional doctrine. Try to decipher how those bodies of knowledge would look at tyranny. And then I come up with contextual factors. For example, is there a criminalization? How close we or far we are from the core of the right? How widespread it is? How much targeting there is? How justified it is? Of course, and this is a very important point, and here I disagree with Peter. I am not shying away from the fact that I am making a judgment based on a certain concept of the good or concept of justice, right? Just because a court said the law is unconstitutional doesn't mean that I'd find it tyrannical, or the other way around, right? So Peter, the fact that the court says this doesn't meet Section 1, that doesn't scare me. Maybe the court is wrong. When I wanted to see if I agree with what John White said, I had to come up with my evaluative parameters for tyranny. And so these are the findings. And of course, I imagine I'm going to be criticized in the question period and even now. Now it's time for the chart. I'll add, yes, the chart. Can I walk, Peter? Can I walk there?
You can walk, but you won't be heard online.
Oh, this is just like hybrid teaching again. I'm so happy.
Here, hold on. You can walk. Hold on.
Oh yeah, and then now, if it's like in my home institution, this is not going to work. Okay. And your laughter says that you are familiar with it from your institutions, right? Okay.
Just speak into it.
No. I have to.
No, it's on.
It's not. Oh, it's on. Yes? Beautiful. Oh, I can actually look here. Okay. So, you have 11 uses. I defer to Caitlin on the actual numbering. You know most of those uses. If we have time, I'll explain each use what it is about. I know that I won't do it, right? The motivation, I only had benign or tyrannical. I'm going to just focus on a few things. And then the impact of rights, I go between
mild and exceptionally severe. Legal effect, I won't get into it now, but I needed to compute something that would account for the fact that some uses of the notwithstanding clause are not constitutional despite the use of the provision. For example, the Alberta marriage bill. And on the other hand, some uses of the notwithstanding clause would be constitutional even without the notwithstanding clause. For example, when the legislature pre-shields a law that's constitutional. In that case, even if I think there is tyranny, I cannot say it's the notwithstanding law that brought it about, right? Because it, right. And so you have a definition of what legal effect is. It's really an attempt to try to mathematize law, because I'm coming from a family of scientists who don't really think that what I do, it's law. But I will say, so I want you to look, for example, at the Quebec sign law. I actually think that the Quebec sign law, the motivation was benign. And I actually think, I read the debates of the sign law and of the religious symbols, and there is a difference. The sign law, I got a sense that there was a genuine fear that French disappears and we need to protect it, whereas the religious symbols, my hunch was that it was much more about immigration than about protecting the French. But look, these are value judgments, and I imagine I'm going to be criticized, as I said. So you can see that the Alberta Marriage Act would have been tyrannical, except it had no legal effect. So I can't say that there was tyranny when the law, right? And what is really worrisome in this chart, and I think that the main reason why I actually think the sign language to be tyrannical is probably something you may disagree with. It's because of the prohibition. I think the notion that you cannot say something gets closer to tyranny unless there is a very strong justification. I'm going to the last use. Here, I actually think I disagree with some of you. I think the actual impact of the Ontario finance legislation on rights is not severe. I mean, had that law been the result of a considered discussion about election finance, I would think that it could be justified. But again, I think it was motivated, and I'm allowed to judge motivation, by a desire to silence the opposition. Therefore, I think it was tyrannical. That's it. Thank you.
It's not severe, but it's corrupt.
Corrupt, I don't know.
But it is corrupt. It's an act of self-dealing, in a way.
Right.
Right?
Okay, thank you.
That's it?
Oh, you said I don't have more time? Can I continue?
You came all the way to Israel just for... Unbelievable.
How long have I spoken for?
No, I'm teasing.
You're teasing me?
No, of course.
Okay,
There's going to be a robust question.
Don't tease an academic about having more time to talk.
Thank you so much, Tsvi. And it's my pleasure now to welcome Professor Christopher Manfredi to the podium, who did not want me to say that he's the provost of McGill, because he's not here in that capacity, but as a political scientist. So forget that I mentioned that he's the provost.
Well, thank you very much, Peter, for the invitation to participate in the conference. Thanks for everyone who's sticking in for the last session. It should be obvious to everyone that I haven't been as active a participant in the scholarly debates about the Supreme Court and its charter as I once was. My time's been otherwise occupied, although I'm not here in that capacity. So nothing I say here should be understood as the official position of McGill University on the Notwithstanding Clause or any other matters that may come up. I actually feel that my attendance here is a bit like a visit from one of the ghosts of scholars past, so you'll have to forgive me for that. But since this is a retrospective on 40 years of the Notwithstanding Clause, I don't feel entirely out of place. There's a title for my presentation in the program, but of course, like all academics, I've changed it, and the paper that I will produce will be called Coordinate Construction and the Politics of Judicial Decision-Making, in parentheses, or maybe the notwithstanding clause isn't such a bad thing after all. Of course, that's a variation on the title of the Hogg-Bushell article that launched the era of dialogue theory in Canada. Dialogue theory recognized the notwithstanding clause as an important architectural element of the Charter that blunts judicial supremacy by giving legislatures a power to modify or reverse rights-based judicial decisions. But I've argued in many places that recognition of the notwithstanding clause's legitimacy as an indispensable element of dialogue theory was somewhat disingenuous, because it came at a moment when the clause itself was on the verge of falling into desuetude if it hadn't already. The unexpected resurgence of the clause in 3 provinces has sparked new interest in its theoretical grounding and practical implication. We've seen papers by Professor Newman around coordinate construction. We've seen a lot of things about textual limitations on preemptive uses and other devices to blunt or defang the clause. And most recently, there's been an interesting article by Sarah Birmingham in Policy Options, which is actually a positive argument for the use of the notwithstanding clause if the Supreme Court of Canada overturns, I guess, the ironically numbered section 33.1 of the Criminal Code, which is a response to Davio. What I want to do in this presentation is 3 things. One is to revisit my original defense of the notwithstanding clause, talk a little bit about the impact of its demise in the 1990s on the strategic relationship between the Supreme Court and between the Supreme Court and various legislatures, and then offer some thoughts on its current use in some of the recent debates. But before I do that, I think it's incumbent on me to be transparent about my disciplinary bias as a political scientist. That disciplinary bias begins with the premise that final courts of appeal, including the Supreme Court, are political rather than legal institutions. They don't make policy as an incidental or accidental byproduct of performing their legal functions, but because a collection of justices decide that a legal rule will produce better social consequences than any other alternative. This is an article of faith among political scientists since C. Herman Pritchett's classic study of the Roosevelt Court in the United States in the 1950s. Political scientists have recognized that judicial decision-making, particularly in final courts of appeal, is driven by policy rather than legal considerations. Cases reach those courts precisely because the applicable legal rules are ambiguous, and legal ambiguity enhances the importance of judicial policy goals. In the early days of the political scientists' view of this kind of judicial decision-making, the focus was on what drove the individual policy preferences of specific judges. More recently, probably beginning in the 1960s, but particularly through the 1980s, there was a recognition that judges, like other political actors, face institutional constraints that force them to act strategically in pursuing their policy objectives, despite provisions designed to insulate them from ordinary political pressures. These constraints, which force justices to consider other actors' preferences, the choices they expect others to make, and the context in which they operate, produce strategic behavior on 2 distinct levels. Justices are, of course, constrained individually by the rules that govern their interactions with colleagues. The successful transformation of individual policy preferences into law on multi-member appellate courts requires coalition building to produce majority support for decisions. Justice William Brennan of the Supreme Court of the United States once used to ask his clerks, what's the most important rule in the Supreme Court? And they would say, well, it's stare decisis, it's mootness, it's the political rules doctrine, the political questions doctrine. And he'd say, no, the most important rule in the Supreme Court is the rule of 5, because with 5 votes, I can do anything. At a more macro level, justices are constrained collectively by rules that govern the relationship between courts and other political institutions. They must be cognizant of the capacity of other institutions either to negate specific policy decisions or to challenge the legitimacy of the court itself. And that's where Section 33 plays a role in affecting the strategic interaction between institutions. So let me turn to the three themes I want to discuss. So first is my history of defending the Notwithstanding Clause before it was cool to defend the Notwithstanding Clause. In December 1988, it was 4 months after I began my academic career at McGill University. As we've heard, the Supreme Court struck down important provisions of Quebec's Bill 101 in the Ford case. Quebec responded with Bill 178, which it sought to protect from judicial review by invoking the Notwithstanding Clause in Section 33. Unlike Marion, I actually consider that to be a preemptive use of the Notwithstanding Clause because, of course, the provisions of Bill 178 were not identical to the provisions that were struck down in Bill 101. So that was something that we differ on. The reaction to that was swift and negative, with a consensus emerging that Section 33 was at best inconsistent with the idea of constitutionally entrenched rights, and at worst, a constitutional abomination. A lot of people have quoted Jean Chrétien and others, but no one has quoted Prime Minister Brian Mulroney at the time, who called Section 33, I quote, "that major fatal flaw of 1981, which reduces your individual rights and mine." Section 33, Mulroney continued, holds rights hostage and renders the entire Constitution suspect. Any Constitution, he concluded, that does not protect the inalienable and imprescriptible individual rights of individual Canadians is not worth the paper it is written on. Now, probably because of the hubris of youth, I decided to write a book to argue that Section 33 was in fact a positive contribution to constitutionalism in Canada, and that was the first edition of Judicial Power in the Charter, which was published in 1993. My key argument to counter the opposition to the Notwithstanding Clause was that that opposition was the product of what I called an historical accident and three conceptual errors. The historical accident was that Canadians experienced a use of the Notwithstanding Clause that they found objectionable before the Supreme Court rendered a politically unpopular charter decision. Even the Morgentaler decision earlier in 1988, and in other places I've talked about some of the strategy around that, did not generate the same kind of political reaction that the use of Section 33 did. The conceptual errors, I argued, were that there was a misunderstanding of the constitutional role of legislatures and courts in liberal constitutional theory. Nothing in that theory, I said, assigned the task of constitutional interpretation exclusively to courts. Legislatures also have a legitimate and important role to play, coordinate construction. There was a misunderstanding of the legislative process as being characterized by the haphazard adoption of measures motivated by majority tyranny, and I guess we'll talk about that. To be sure, legislatures, I said, can act both irrationally and arbitrarily, and judicial review provides an important check on these pathologies. So the book is not an argument against judicial review. It's not even a book about judicial activism. That phrase only appears 7 times in the book. An important check on these pathologies of legislative behavior. Nevertheless, I said, the judicial process itself suffers from its own institutional pathologies when it comes to evaluating complex policy choices. And finally, I said there was a misunderstanding about the nature of charter adjudication. Although charter cases raise fundamental questions about rights or moral principles, the dispute in most cases is about whether the legislature has chosen the least restrictive means of achieving an important policy objective, something about which I would say courts didn't have any particular expertise beyond, above and beyond legislatures. So I said that the Notwithstanding Clause, and this is a direct quote from the book, it may seem familiar to you, quote, can have a positive impact by encouraging a more politically vital discourse on the meeting of rights and their relationship to competing constitutional visions than what emanates from the judicial monologue that results from a regime of judicial supremacy. So I was in favor of the dialogue theory before I was against the dialogue theory. I wasn't the first person to make that point, and of course it did become the core proposition of dialogue theory, although I claim no direct influence for it. I did suggest that there were 3 key deficiencies to the Notwithstanding Clause. Those were that it implied or sent the message that legislatures were overriding rights, that they could do so preemptively, and they could escape political accountability for having deployed the Notwithstanding Clause. I propose some textual changes to address the first two deficiencies. That would be to insert a phrase that would read that notwithstanding a final judicial decision that a statute limits, etc. And the point of that was to make it clear that the legislature was not overriding rights, it was overriding a judicial definition of rights or judicial interpretation of rights, and it would at the same time prevent the preemptive use. I also suggested that the notwithstanding clause should only be invoked with following a 3/5 majority vote, and that you would also be, the sunset clause would be extended to have effect at the dissolution of the parliament or legislature that enacted it. And that would absolutely force potential reenactment to be an electoral issue. Well, youthful hubris basically transformed into early middle-age cynicism, and I became increasingly pessimistic that Section 33 was in fact, quote, encouraging a more politically vital discourse on the meaning of rights in the relationship to competing constitutional visions. And that manifested itself in two ways: a series of articles beginning in 1999, which were critical of the dialogue theory as it had emerged from Hogg and Bushell. And then a second edition of Judicial Power in the Charter to update its review of the court's impact on public policy and to try to understand why legislatures by that time had lost most, if not all, of their authority to define rights. It posed the question of whether the demise of Section 33 as a viable response to judicial decisions had emboldened the court in pursuing its ideal policy preferences. And here, I think I will skip over this part just for the sake of time, but there's a long argument about how the potential use of the notwithstanding clause affects the strategic interaction between courts and legislatures, because what courts want to do is they want to avoid the invocation of the notwithstanding clause, because that has two effects. On the one hand, it will negate the immediate policy preferences of the court's immediate policy preferences, but it will also, over time, undermine the court's claim to, if you will, supremacy over the meaning of the Constitution. So let me conclude by just offering some reflections on the debate that's sort of emerged. The reaction to recent uses suggests that the legitimacy of the clause remains low, although it has become a bit more visible, and some provinces are finding it more useful to use. We've talked about the Quebec's use, Ontario's use, Saskatchewan's use. I consider all three of those to be preemptive by my definition, because in none of those cases has there been a final judicial decision. So I think that all three of them are, from my point of view, illegitimate uses of the notwithstanding clause because they're preemptive. I don't know if there's a remedy to that. A second point is, are the deficiencies that I identified in 1993 being, if you will, corrected naturally? The historical accident question. Well, as Birmingham recently suggests, the outcome in Sullivan and Chan may generate the odious Supreme Court of Canada judgment that reorients attitudes towards the notwithstanding clause. Kent Roach, of course, called Section 33.1 of the Criminal Code an in-your-face legislative response that should have come with the use of the notwithstanding clause. I, of course, don't think it should have come with the use of the notwithstanding clause, because again, that would have been a preemptive use of the notwithstanding clause. If the court is very concerned about the strategic implications of the notwithstanding clause being invoked, it could do two things in that case. It could determine that Section 33.1 is a reasonable limit on the right articulated in Davio. I think that'll be very difficult, because I think Section 33.1 really is an in-your-face response, as Roach says. So here's my radical proposal to the court. Declare that Davio was wrongly decided, thereby making 33.1 redundant. Remember, there were 3 dissents in Davio, and there's evidence of changes in the position during internal. There are evidence that the position of the justices in Davio actually changed during internal deliberations. If you see where the the facts and the summary of the law is. The preemptive use deficiency. So I think some of the work by people who've been here, Leckie, Weber, Mendelsohn, Mary Eberts, about defanging it, has provided an interesting, but I think only partial solution to the deficiency of preemptiveness. Because for the court to adopt any of those suggestions, it would be making a political choice. It would be making a political choice that there's something illegitimate about the notwithstanding clause, and so it wouldn't. To me, it would not. It would not reorient the balance. So I think they're intriguing, and I've actually thought about this as a way of getting rid of preemptive uses, or at least negating the idea of a preemptive use, without having to actually go through changing the text. The circumstances that produced Section 33 inhibited the political development of a coherent theoretical justification for the legislative override. We've heard all about Jean Chrétien's justification for it. Section 33 has not inhibited the expansion of judicial power under the Charter. That this has occurred is hardly surprising. Constitutionally entrenched bills of rights inevitably enhance the power of final courts of appeal. Although it is useful and important to debate the normative implications of this shift in power, its legitimacy or illegitimacy is somewhat beside the point. Greater and more active use of judicial power under the Charter simply is. In my view, judicial activism is not that difficult a concept either to define or to identify. At its core, judicial activism is the willingness of courts to reverse or otherwise alter the policy decisions of legislatures and executives. A court that never did this would be entirely deferential. A court that always did it would be completely activist. In the real world, of course, no court's behavior reflects either of these extremes. In practice, this means that every court is at least somewhat activist. Although reasonable people may disagree whether a court has been too activist or exercised its activism outside the parameters of its constitutional authority, it is possible to compare levels of activism across different courts or on the same court at different periods of time, and that's what I think political scientists should be doing. Thank you.
That was wonderful. Well, your work of many years ago cast such a long shadow over the discussion and the evolution of both the law and the thought in this area that it was well worth you revisiting it and updating it and reconsidering some of your old positions and justifying them. It was fabulous, and we're going to kick off the very last session with an extraordinary speaker, the executive director of the Samara Center and a fellow here at Massey, Sabreena Delhon, who's going to talk about problems of politics and power and the misalignment of authority and motivation.
Thank you.
Welcome.
Good afternoon, everyone. It's such an honor to be part of this conference. Thank you so much to Natalie and Peter for the invitation. My name is Sabreena Delhon. I'm the Executive Director of the Samara Center for Democracy. The Samara Center is a nonpartisan charity and civil society organization. Our aim is to make democracy in Canada more accessible, inclusive, and responsive. My goal over the next few minutes is to explore the current democratic context for the use of the Notwithstanding clause. And I'll be speaking from a civil society perspective today and using my lens as a sociologist. And my aim here is to trace how overrides affect public trust and legitimacy of governments in order to inform lessons for democratic revitalization in Canada. So I'm really pleased to pick up threads from Professors Cameron, DeRosier, and Leckie, along with Ms. Wiebel and Ms. Salvino from earlier, and of course build on what my fellow esteemed panelists have shared so far. The Notwithstanding clause is a uniquely Canadian compromise. It's one that allows provincial and territorial governments to override certain sections of the Charter for reasons of public policy. I think everyone here knows that, but for the benefit of people tuning in, they could be diverse, especially if they're Samara fans, so I'm going to lay that out. Those involved in its drafting were cautiously optimistic that Section 33 would be rarely used and that any prospective use would be subject to vigorous political debate and civic participation, thus resulting in great political accountability. Manitoba's Attorney General at the time lauded Section 33 as exemplifying the right to use the authority of Parliament and the elected legislatures to identify, define, protect, enhance, and extend the rights and freedoms Canadians enjoy. Similarly, it's been assumed that the reenactment of the override power every 5 years will allow voters to issue their own referendum on a government's use of the power and will result in a change of government. Section 33 thus assumes a third party in the perpetual dialogue between the courts and the legislatures in Canada, that being an active, informed, and empowered electorate. Yet dialogue is, as we've explored, an imprecise word, subject to different interpretations and contexts. For example, constitutional theorist and law professor Roberto Gargarella critiques the dialogue that is meant to ensue from the invocation of Section 33. He argues that the existence of severe social inequalities and the prevalence of institutions that are not well prepared for the promotion of an inclusive dialogue seem to seriously conspire against the potentials of an egalitarian dialogic practice. Recent years have seen what scholars describe as a democratic recession or a democratic backsliding. This entails an erosion of checks and balances, a hollowing out of institutions of accountability, and a shrinking space for civil society. Low public trust in elected officials, the spread of misinformation through social media, and a tenuous sense of belonging are all variables that are readily challenging democratic values in Canada. This has all, of course, been exacerbated by the pandemic. Although the Economist's Democracy Index puts Canada in 5th place, we should not be complacent. Recent surveys have shown that partisan identities shape how Canadian citizens approach public health measures, such as wearing a mask or getting vaccinated. In addition, during this extended emergency, we've seen a rise in polarization and related acts of violence against the Asian community. We must also pay attention to the polarization that occurs within our media institutions. While we assume that they can drive independent debate about the Notwithstanding clause, a recent empirical research project found that the ideological orientation of various news outlets is strongly associated with how Section 33 is portrayed. In this period of democratic backsliding, we face urgent and complex challenges related to trust, risk, and knowledge. Much of the historical debate around Section 33 assumes that the political sphere is open and inviting to all Canadians, but there are many indicators that this is increasingly not the case. This circumstance is linked to the fact that people are immensely disenfranchised from their justice system. The 2021 Race and Criminal Injustice Report found a perception of bias in the criminal court system among a significant proportion of respondents, namely among Black and Asian participants. A 2016 study measuring how Ontarians perceived the justice system found that the majority of respondents described it as oppressive, not representative of all Ontarians, and intimidating. Furthermore, 4 out of 10 Ontarians saw the justice system as unfair, regardless of their race, gender, age, or income. This is pre-pandemic data, so it stands to reason that results would be even worse if the study were run today. This is because problems such as wrongful evictions, family breakdown, domestic violence, hate crimes, and employment issues have surged during this extended emergency, leaving both marginalized and middle-income individuals with little recourse. We know that COVID-19 has had a disproportionate impact on low-income and racialized communities, long-term care home residents, frontline workers, and incarcerated individuals. Across these categories, women are bearing the brunt of adverse outcomes, and these groups are also most likely to face barriers when casting a ballot. This feeling of alienation and disengagement is further emphasized when people go online. We need to be responsive to how technology is shaping our current democratic context. Online platforms amplify harmful content in a way that is out of proportion to its prevalence in the real world, distorting our public sphere as well as our social norms. This circumstance is what inspired the Samara Center's recent SAMBOT project. Here, we used a machine learning bot to track toxic tweets received by a selection of candidates in the recent federal election. In addition to counting the number of tweets, we also analyzed the text for toxicity attributes to determine sentiment. We did this because the amplification and abundance of toxicity online is a barrier to civic engagement. It's a key reason for why people leave politics, don't enter politics, or just avoid the political conversation altogether. In 1 week alone, during the campaign, we captured about 500,000 tweets aimed at 300 accounts. 4% of those tweets were sexually explicit. That sounds like a small number, but it translates into 20,000 tweets coming at just a handful of accounts. And again, it's just within 1 week. 7% of the tweets from that week contained identity attacks. That's about 34,000 tweets. Overall, in our tracking during the election, we found that women candidates got more toxicity than men. I don't think that's a surprise to anyone here. And also that the content was generally misogynistic and personal. This torrent of digital vitriol, the very limited trust in the justice system, and the adverse experiences of the pandemic make for urgent problems that can permanently sever one's civic connection. This is where the electorate is at when overrides are employed. The legitimacy of our governments and our democracy are directly connected to how institutions manage their relationship with the electorate. If the expectation is that voters play a critical role in assessing the use of Section 33, then we as a society need to ensure that they are sufficiently enabled to do so. What can be done to ensure the electorate can effectively play their part? How can the relationship be repaired so that the electorate views institutions as worthy of their trust? How can they be activated and engaged to view not just their vote, but their broader democratic presence and participation as something that is valued? For Hari Han, a professor with expertise in civic engagement, the challenge of democracy in the 21st century comes from a society that has neglected the challenge of enabling people's power. In order to stay relevant and retain their integrity, institutions of democracy must work quickly to adapt and reflect our pluralistic, multiracial society. This requires cultivating a new kind of leader, one that can balance tensions, one that can move with ease from the top down and bottom up, someone that can adeptly navigate institutional and constituency demands. We are seeing the practice of democracy go through a rapid transformation today, one that entails rethinking how the public holds its leaders accountable. For Han, either those who have the motivation to make change lack the authority or capacity to act, or those who have the authority lack the motivation. Solving problems of power, then, requires bringing motivation and authority into alignment. This alignment can come from reinforcing the importance of the electorate. Innovative forms of public participation, such as citizens' assemblies and reference panels, can help to guide this shift. These approaches fall under the broader practice of deliberative democracy, which, when properly implemented, can strengthen the civic capacity of the public, enhance trust of democratic institutions, and produce informed solutions to complex problems. This is not a magic bullet by any means, but it could help signal an important shift that reverses democratic backsliding by repairing the relationship between the electorate and their institutions. We are facing a critical opportunity to evolve. As we've explored together over the past 2 days, the development of our charter was during a golden age for Canada's democracy. Declarations against the Charter were taboo 40 years ago, but now norms are changing. With the rise of populism and the tendency of governments to narrow their accountability to their supporters rather than the broader electorate. Instead of panic or passivity, let's be proactive by providing an opportunity for increased transparency, accountability, and engagement through public deliberation. It's important to remember our history and learn from it, but we mustn't be nostalgic. For as one golden age ends, we can set about realizing the next one. This can be achieved by broadening our democratic imagination to develop meaningful and responsive support for the electorate. Thank you.
You could sit there or there, wherever you prefer. That was wonderful. Sabreena, you've opened a whole new can of worms. That for yet
The fourth conference?
Yes, this is the fourth conference, and I know there's going to be questions. So let me just kick it off with a question to you, just one of clarification. Are you saying that, are you making an empirical claim that use of overrides erodes public trust and creates kind of political institutional legitimacy deficits? Are you saying that your studies have shown that use of overrides produce that effect? Is that the claim?
Yeah, I have to go there. So we haven't empirically measured that, although it is something I'd be interested in doing at the Samara Center. My aim is to illuminate the context where there's increasing alienation and disengagement, and then the electorate can't play their role in holding the systems to account that they're supposed to. So that can give rise to more use of Section 33 in ways that don't feel democratic to a lot of us in this room, and it can create conditions in Canada that compromise our democratic culture.
Thank you. Are you okay to sit there then? Marion, do you want to go next?
Thank you all. Sabreena, thank you so much for being here and offering your comments. I have to admit, when you were going over the tweets, it made me sick to my stomach what you were talking about. But thank you for ending on a optimistic note. Mary, I just want to say, as you were describing the work that you've been doing over decades, I thought I wouldn't be here today without that work, so thank you. Chris, you may have noticed I cited 2 papers in a book that you edited today, so I am connected to your work, and it's not a ghost. That work is extremely relevant. And Tsvi, I have a question for you about the chart that I need to examine very closely, but I put a lot of emphasis in my talk about the mechanics of the different uses of the clause, and I'm wondering to what extent, for example, targeted versus total, I'm wondering to what extent that figures into your analysis of what box does that fit into, if any? And if not, why not? Thank you.
Right. Do you want to go? Sure. Right. So the one thing I actually don't look at is the legislative appropriateness of the use. That is, I don't mind if legislatures are, I do mind, but that's not the inquiry. I don't mind if they're irresponsible, if they're lazy, if they are smart or not. So for example, I don't think that the omnibus use is an issue. I think the motivation was benign. It was political protest, which we could disagree with, but it's not a crisis, right? I think the result was suspension of the charter, but the continuous, right? And so I actually would be indifferent to the question of whether I wouldn't care if you target 1 right or 5 rights. I would have to look at the result. So for me, but what I meant is that when I look at the result, I look at how many people, for example, were affected or something like that. But I didn't look at how many rights were affected, but rather on the impact or potential impact on right holders.
Thank you all very much for wonderful presentations. My question is also mostly for Tsvi. I was very attracted to your presentation in terms of how you classified both motivation and effects as both relevant in different ways for the legitimacy of the use of the Notwithstanding clause, with the former perhaps being disqualifying, but in exceptional cases the latter is very important as well, even if the motive is benign. So that strikes me as very good, helpful for understanding the legitimacy of particular uses of Section 33. But I'm still curious from a doctrinal perspective, what are the implications of that? Notwithstanding that very interesting analysis, what can a court do with it given the procedural antecedents seem to be the only limits on the use of Section 33, subject to the discussion about what operation means, and that may not preclude certain remedies, but...
So the short answer...
You got that answer up there.
The short answer is that what the court can do about uses of the Notwithstanding clause that are tyrannical is roughly what the court can do about the weather, which is nothing. And I actually...
But I think Mary Eberts might differ with you on that, right?
I was talking about this is not, like, I could write a different paper on that question, but I don't have a view on that. In fact, where I come from, Israel, there are tyrannical laws all the time, unfortunately. And there is this new doctrine, recently, a year and a half old, whereby the court could strike down, listen to this, a provision of the Constitution if it is too oppressive or if it doesn't respect the democratic nature of Israel. I think it's wrong. I mean, I distinguish between constitutional level, and I don't believe in the notion of unconstitutional constitutional amendment. So, and I think that I don't think I mean, again, I don't get to the, I'm not, my thesis is indifferent to the question of what the court may do about tyrannical use of the Notwithstanding clause.
I think in fairness, so you can push yourself a little bit.
Oh, if I push myself.
All right, I think you do either land with Mary, that there is at least the barrister seeking a remedy from the court, saying that in cases of a tyrannical use, to use your nomenclature,
right,
it could be deemed to be an improper use. And let's not get into what the criteria are.
No, but
it's either that,
yes,
or you have to land on the side of constitutional amendment to repeal or otherwise modify. You can't just land in no man's land here.
So my project was to evaluate historically whether, for example, whether it was a good deal to Canada. Obviously, the answer is yes, right? Whether having a charter was a Notwithstanding clause, or whether we should or should not repeal the provision, which I think we should, though I don't think we would, right? But I don't think that my thesis about tyranny is committed to any particular view about what to do with it. This is what I think.
Before we take the next question, I wonder if I could just clarify something.
Sure.
My analysis of the statute and my hope about what one could do about use of Section 33 doesn't have anything to do with tyranny.
Okay.
You know, I would love to be able to have a direct pipeline to judicial review because of attitudes like Premier Ford's, for example, self-seeking and so on. But I decided that it was too difficult to manage from a litigation point of view. You wouldn't be able to establish any standards by which to assess whether something was tyrannical or fraudulent or whatever. So I just thought I'd go with the statute and what you could make of the charter itself and the values in the charter and the process that's set out in the charter for any legislative behavior.
Right.
So I just take motive out of it entirely.
Okay, fair enough. Fair enough. Robert, thank you for that clarification.
So Mary, you're back. I was intrigued by your mention of the idea of bringing a claim under Section 24, saying, look, my rights and freedoms have been violated. I'm looking for a remedy. I've written that maybe when the Notwithstanding clause protects a law's operation, maybe in certain cases a plaintiff could get damages, saying, look, it's wonderful that Quebec is trying to purge the public schools of hijab-wearing teachers, but why should a small minority of women bear the costs for a broad social policy? But my understanding was you were thinking under Section 24 that one could ask the court to simply not give effect to 33. Was that what you were going for?
Well, my theory, I guess, is operating at two levels, and that is, I want to get a direct assessment of whether the rights under the sections which have been overridden have indeed been violated. And in order to do that, I have to establish that the use of Section 33 was inconsistent with the requirements of the Charter, which I derive from the whole of the Charter. And if the use of Section 3 is not in accordance with the Charter, if it's inimical to the whole ethos of the Charter, then presumably it would not protect the legislation. And you could proceed to a direct argument about whether those rights had been violated. And I look at Section 24, and I say that, the person whose rights and freedoms are guaranteed by the Charter, well, there is a guarantee in all of these sections, but the question is whether they are still guaranteed if they've been subject to Section 33. And the other thing is if the rights have been denied. So maybe you could say that Section 33 is a denial of rights. So it really turns on the construction of Section 24. And I would think then that if you could get through that, you would ask for anything that you could get under Section 24. That is a straight striking out or a declaration with a postponed declaration so that Parliament can fix it, damages or whatever. You're not just limited to a declaration simpliciter.
Bruce and then Guillaume. Oh, I'm sorry, Richard.
Yeah, that's fine. That's fine.
I don't know why my brain said Bruce.
Since I go by Dick, I'm understood as being called many things that are worse than that.
I apologize for that. Sorry.
No, not at all. We speak about tiering the majority or the majority will and so forth, but the reality is in our system, our parliamentary, multi-party parliamentary system, generally speaking, governments may hold a majority of seats, but often on the basis of a plurality of votes. That is to say, 38% is often enough to become a majority government. I wonder to what extent that can factor into our understanding of Section 33. So, for example, it provides maybe additional support for your idea, Christopher, of a supermajority to invoke Section 33. So I just wanted to kind of, throw that up there.
You want to respond?
I think that's correct, and I think what's important to understand is that in a properly functioning liberal society, there is no permanent majority. Every law is developed. The majority that underpins every law is the product of a shifting coalition of minorities, actually. So there are certain, I think Caitlin mentioned it this morning about Eli. Eli's point, of course, is that there are certain discrete and insular minorities who can never be part of the shifting coalition that makes up the majority. And those groups need special protection from the court. So I think there's an argument to be made for those particular permanent minorities. And I think such groups exist, but I actually think they're rarer than we think they are. So this notion that there is a tyrannical majority that is kind of closed off from the rest of society is one of these, I think, conceptual misunderstandings. They exist, they can exist. And in those cases, I think there's a very strong argument for the use of judicial power. But it's this notion that every majority is actually the product of a shifting coalition of minorities. And that's why a 3/5 idea is important, because it really does make that, it kind of operationalizes that idea.
Interesting. Guillaume.
Yes, thank you for your presentation. So my question is for Tsvi. Of course. So the question is, I think it's pretty simple, is how important is the context when you qualify a use of the notwithstanding clause as tyrannical? How important is the broader context? I'll take one example. If we look at the Charter of the French language, suppose there was such a thing as the Charter of the English language in Ontario, with really strict rule about commercial sign must be in English and so on. I mean, that would be tyrannical. I think a lot of people would agree that such a use of the notwithstanding clause for a Charter of the English language in Ontario will be tyrannical. But in the case of Quebec and of the Charter of the French language, I see the issue differently, and I wonder if you do also take into consideration the context with that example in mind or any other. Thanks.
Right. So the short answer is of course. And I think, for example, if let's talk about the sign law, for example. If the sign law said that if your sign is in French, you get it funded by the government, but if the sign is in English, you have to pay for it yourself, I would be okay with it. And of course, we can get into a lot of details. Remember, my comment to you, and maybe I'm doing the opposite. Maybe you're saying, well, it's Quebec identity, then it's okay. And maybe what I am heard by you to be saying, well, it doesn't respect the English language, so it's tyrannical. So maybe the devil of tyranny is in the details, right? And from what I was, and of course, I think that, as I said, and I said it, when I read the debates, and back then there was no Google Translate, and I had to get them translated because I don't speak French. Now I speak a little bit, and I also use Google Translate, so I can do it myself, but I was a PhD student, and I had to get a special fund for the debates of P 178 to be translated. And there, I was experienced that the motivation was genuine concern about the future of the French language. For example, here's an example. The court in Ford said that the complete prohibition on English is unconstitutional. What would have been constitutional is if there was a requirement that English is dominant, if French is dominant. It must be my bias. So one of the legislators, I forget who, said, no, that's wrong. Because if the immigrant who just came to Quebec, if he knows he can get away with English, he will not learn French. So you could think that that's a horrible way to social engineer, but at least what I saw in that reasoning was a genuine concern about English. When I read the debates recently, and again, we don't have to get into the details of that. And as I said, I imagine you're proud Quebecois and I'm proud Israeli, and there are several laws in Israel about which I would say worse thing that I'm saying about this law in Quebec. The reason why I find the specific, notwithstanding the context, the reason why I find the last use in Quebec tyrannical, and Bill 96 did not pass yet, so I think I'm tired of it for a few years. I'm not going to do more. But the motivation I found, as I said, was based on whatever I was able, wasn't mostly to defend the French language. It was something about immigration. And the consequences that had to do with people's jobs. This is, I mean, John Rawls says primary goods, one of them is a position, a potential position within government, right? So it's a very big deal. And the last thing I would say is this. Just because a law could be justified based on context doesn't mean that it was genuinely motivated by that context. I think that's enough.
Yeah, we've got time for one quick question, and we have to wrap up. Jeff.
Well, my question is for Professor Manfredi, who is, I agree, the OG defender of the Notwithstanding clause. That means original gangster. And I just have my question is whether or not you could elaborate a little bit more on why you think that preemptive uses aren't a good idea or aren't legitimate, as you said, and whether or not there are other factors and other variables at play that might change and make it such that there's a world in which you think that they could be. So, for example, I think the preamble to the Saskatchewan law sets out really nicely, actually, some of the religious freedom concerns in a sophisticated way at stake in that dispute. And does that help legitimize the Saskatchewan law, or in it, which you call it? You said it was preemptive, even though it was responsive, right? In any case, I was hoping you could give us more of that case you have against that.
Take this off without tearing my glasses off. I guess it comes from my understanding of coordinate construction, which is coordinate construction requires that neither the courts nor the legislatures be foreclosed in offering an opinion or a judgment on the constitutionality or on what a constitutional clause means. And so my understanding of the Notwithstanding clause used preemptively is that that's precisely what it does. It forecloses the possibility, notwithstanding the arguments that Robert and Gregoire made and that Mary Eberts have made, notwithstanding those arguments, that as I understand a preemptive use of the Notwithstanding clause is that it forecloses the possibility of a judicial statement on the meaning of a constitutional right. And to me, that goes contrary to the notion of coordinate construction. So I think that's the reason why I don't like, or I think preemptive uses Notwithstanding clause are illegitimate.
It's for you, Professor Manfredi.
Stay up there.
The discrete and insular minorities, and in the context of these reconstructions of majority that are not haphazard, but kind of coalesce for one purpose. And you said there are fewer than we think, or fewer than are alleged permanent excluded. And I just wanted to push you a little bit on that. Sure. In terms of, typically I think we look at, and Caitlin makes the point, minorities, so, I think we could say, okay, who are the minorities? So would say, would the, black people in Toronto racialized, the racialized people who are beaten up by the police, for example, is in the criminal law context, would you say racialized people, in light of what we've seen, are a discrete and insular minority, and therefore the courts owe it a special, is that?
Yeah, so I think there are two things. One is, of course, discriminatory behavior by individual actors of the state can always occur, and of course that needs to be punished for what it is. The question then becomes, what do you do? Are there going to be structural changes to the way in which police departments operate or the laws that govern police departments? It seems to me that there are very few groups that are unable to build coalitions with others that can try to influence that. So that's the notion of insularity. If you look at what discrete and insular means, I think there's certainly lots of discrete groups. Insular in the sense of being completely removed from the possibility of participating in the political process, even through the device of building coalitions with other members of the majority. Of course, African Americans were the classic. That's where the phrase comes from, because as slaves, you were clearly both discrete and insular, and the whole legacy of that. So
and refugees, or people that don't have the right to vote.
I think refugees are another. But again, there are civil society groups that advocate on behalf of refugees. Is that sufficient?
Yeah.
That I think is an open question.
So, and who would you put in that permanent? You said there are fewer than we think, but do you accept that there's any?
Oh no, I think you've named some groups that I think we have to look
Indigenous.
very carefully. Indigenous Canadians are among that. I actually don't think that Anglophone Quebecers are a discrete and insular minority myself. That doesn't make me very popular among some of my colleagues, but you're right. There are some groups that don't have that don't have political rights at all. I think are the ones that we have to really be careful about.
Thank you very, very much. First of all, let me just thank this panel, this fantastic panel. And I'll ask Natalie to come up and see us off. I just want to say from my part, I'm just so thrilled that you were all here. You made one of my dreams come true, a good conversation amongst first-rate minds thinking about important problems. I hope that some of your minds have been, if not changed, certainly open. Mine certainly was, and I greatly appreciate what we've done together the last couple of days. And your reflections will find their way into a volume that we're working on shortly. And I hope that we can, that this conversation continues. In any event, thank you so much for all that you've done, coming together and making this a wonderful 2 days. Natalie.
Moi aussi, je voudrais vous remercier tous et toutes. Thank you very much, all of you, for participating, for engaging, for being here and staying throughout the afternoon to continue to debate and think about these important issues. You're always welcome at Massey College. We are in the process of thinking about what we're going to do next year. So ideas about new conferences or small debates, and if we wanted to do a more in-depth reflections, I'm all ears and quite open to invite you again. I really am looking forward to the publication. So that means that I think we're hoping for people to send their texts. I think the richness came from the diversity of points of view, and therefore we would want to see that richness reflected in the book as well. Alors, merci beaucoup, puis à la prochaine.